Hi, I'm Ashley, and I will be providing a presentation for you on Melton's pages 161 to 162 and 176 to 177 regarding competence to refuse an insanity defense and other mental state defenses. Decisional competence in parens patriae. Decisional competence refers to the finding of an individual's ability to make a particular decision. Parens patriae refers to when the state is provided power to make decisions for those who are deemed unable to care for themselves. However, since the mid-19th century, Western society has begun to believe parens patriae should only be used if the individual in question lacks the capacity to make certain decisions. Court case Godinez v. Moran. In Nevada, Tom Moran entered a saloon August 2nd and shot the bartender and a patron both 4 times with an automatic pistol. 9 days later, Moran turned up to his ex-wife's apartment and shot her, hitting 5 of the 7 shots he fired at her. Following this, Moran shot himself in the abdomen and slit his wrists, but survived. The bartender, patron, and Moran's ex-wife all died. Godinez v. Moran continued. Moran was found competent to stand trial and represent himself. Though he was found by 2 assessing psychiatrists to have depression, it was not viewed as a factor that would impair his ability to stand trial. Moran waived counsel as he aimed to diminish a defense for himself, and he wanted to prevent the presentation of any mitigating evidence to the court. So basically, Moran did not want any evidence that he had any mental illnesses or things of that nature, such as depression. He didn't want any of that presented to the court or used in his defense. At the time that he refused counsel, he was taking 4 medications: phenobarbital, Dilantin, Inderal, and Vistaril. These medications were noted to produce side effects such as lightheadedness, drowsiness, depression, confusion, and memory impairment. Godinez versus Moran continued. Moran was asked in court if he killed his wife with premeditation and malice, to which he responded that he didn't know. Moran stated that though he intended to pull the trigger of the gun that killed his ex-wife, he had not planned to do it. He stated, "I wasn't looking to kill her, but she ended up dead." That is discussed on Melton, page 162. After further discussion with the court, they came to the conclusion that Moran's actions were deliberate. He had a discussion with the court during his case, and they were trying to find out if his actions were deliberate and with malice, and he understood what those meant, but he couldn't get through the idea that though he did not show up to his ex-wife's apartment to kill her or with the plan to kill her, but when he pulled the trigger on the gun he planned to kill her, that meant that it was with premeditation and malice. Moran's competency. Moran was found competent to stand trial and waive counsel to represent himself. He was sentenced to death for the saloon murders and given a life sentence for the murder of his ex-wife. Further court cases go deeper into discussion for the matters involving competency to stand trial, especially in cases of the insanity defense. We will address those now. Whalum versus the United States. Judge Bazelon urged for the insanity defense to be imposed by trial judges when the defense would likely succeed. So Judge Bazelon wanted people to take on the duty to introduce insanity defense information and evidence and proof to a court if they believed that the defendant would be found insane. When a defendant aims to keep mitigating evidence from being presented, such as in Moran's case, it's then questioned whether there's a duty to present the evidence anyway. This follows the belief that incapacitation due to age or mental condition relinquishes responsibility from the acts committed. I will be including a video linked with this presentation in regards to the insanity defense, how we find people insane in the eyes of the court, and how it relinquishes the responsibility from the acts committed by the individual. Frendak v. United States. This case brings up the idea that if an individual is capable and competent to make a decision in regards to their case, that they have the right to decide whether an insanity defense is to be used. This is different than the stance for Whalum versus United States, because an individual following the Friend Act case may choose not to include evidence or plead to an insanity defense, whereas one following the Whalum case may argue it's the duty of the members of the court to introduce evidence and provide reason as to the insanity defense for the defendant. However, Whalum was overturned in the United States v. Marble, and Friend Act's the majority perspective now. So most people do believe that we should not go in and force to introduce mitigating evidence or, overturn the beliefs of the people who don't want to use the insanity defense. If they don't want to use it, they shouldn't have to. Reasons a defendant may refuse an insanity defense. It may result in a longer period of confinement than a regular criminal conviction would. So usually, and as we've already learned, if somebody's provided the is given the insanity defense and they're found guilty with that, they would usually do, some type of treatment and rehabilitation in a mental hospital rather than in a prison. And these sentences are usually longer than the time they would have spent in prison. The next reason, they believe they would receive better treatment in a prison than in a mental hospital. Third, there's a desire to avoid stigmatization of mental illness. So that's a big one, and that's a pretty big recurring topic in regards to the insanity defense and why people don't want to use the insanity defense in general, is the stigmatization of mental illness. They don't want to be viewed and seen as mentally unwell. I remember a week or two ago in our modules, we discussed someone, I'm blanking on their name, but, they didn't want the mitigating evidence introduced because they didn't want people to view him as weird because he had schizotypal personality disorder and autism spectrum disorder. Being committed to a mental hospital may result in loss of some legal rights. That's another reason people don't want to do it. And they also could believe that their crime was viewed as a religious or political act, so the insanity defense is negated. Insanity defense continued. Sometimes it can be called the mitigating evidence be presented in instances involving the death penalty, as it may change the stance of the case. So that's a big one. If somebody, doesn't want to introduce their evidence and present it to the court for their mental well-being, but it is on the, in the cards on the table that they could receive the death penalty, people may want to introduce that evidence to the court as a way to kind of defend and speak up for the defendant. It is important to determine if the defendant's rejection of the insanity defense is due to the rejection of their own mental illness or the idea that something is wrong with them. There's a big discrepancy between believing that something is wrong, like not wrong with you, or that you don't want people to see you as mentally unwell, like you can't take care of yourself, can't control yourself, and just not being able to make decisions for yourself. My reference is Melton's textbook. It got kind of messed up there. And then my discussion question for you all. Should an individual have to face institutionalization rather than incarceration if they denied the insanity defense, but parents Patry presented mitigating evidence to the mental state of the defendant due to the possibility of the death penalty? Thank you.